All right, everyone. Welcome to another edition of Disability Talk Live. I am attorney Anthony Reeves, so let's go ahead and get this thing moving and grooving, popping and locking. All right, first of all, let me check out something because I actually had a question ahead of time, so I want to make sure I address that accordingly. So give me 1 second. Okay. I had a question that was posed. It says, before we start talking about the evidence and so forth, somebody asked, what do I do to get SSA-OIG agent to stop harassing me and deferring my Social Security for back payments? He has stopped my check. All right, let me say something that's probably not going to be very popular, and you're probably not going to want to hear this. But before I roll in, let me throw this out here. You have an ongoing duty to prove you're disabled. That just doesn't go away once you're found disabled. So I say that to people all the time because a lot of times what happens is that people think that when they get approved for disability benefits, it stops there. They know that a review is going to happen, but in the grander scheme of things, they don't look at it from that standpoint. In their minds, they're thinking that, you know, I got disability benefits, the government has proven I'm disabled, leave me alone. Doesn't work like that. You have an ongoing duty to prove you're disabled. So if there's an investigator looking at your case for whatever reason, they have a right to do so. Now, you have a right to appeal if they make a decision that's not favorable to you. But I want to stress, and I cannot stress this enough, you have an ongoing duty to prove you're disabled. So please don't get it in your back of your mind that just because you got disability benefits, that the government should just leave you alone, because it just does not work like that. So they're gonna, if they have a reason to believe that your condition is one that warrants a review and it happens, just be advised, it's gonna happen. All right. So let's go ahead and get cracking on here. As I've said before, for those of you who haven't had a chance to participate with me live, let me go ahead and tell you how this thing operates. First, typically what I do is somebody will usually ask me questions in advance, and I will start my discussion focusing on the thing that they asked me to talk about. If by some chance you have a question you want to ask me, do not think that just because I'm going over this topic that you cannot jump in there and ask your question. Go for it. If you got a question and you got something to say, make it do what it do, ask away, and we will call it a day, okay? And I'll be more than happy to stop what I'm talking about and then go right back to what I'm doing. So I want to say that to kind of set this up. So let me just go ahead and do my little friendly, you know, welcome to Disability Talk Live chat. All right, a couple things that you need to be aware of. I was asked to talk briefly about the new changes, which was the revision to the rules regarding the evaluation of medical evidence that actually, I believe, goes into effect on March 27th, 2017. We use what's called rulemaking, federal rulemaking, and that's not the most formal term, so I know somebody hears this will say that's not the actual term. I was like, well, it's actually rulemaking. What happens is Social Security has rules and regulations, and on occasion they will revise those rules. They will afford individuals the opportunity to comment on those rules, and then based on those changes and so forth, they'll make those rules, they'll make those changes accordingly. A lot of times the rule revisions are more cosmetic in nature, but every now and then they have things that are what we call substantive in nature. So in this particular instance, it looks like they made about 15 particular revisions. So I'm going to go through them fairly quickly, and if there's anyone in particular you want to know about, I can hit, and after that, or in the middle of this, once I'm done, if you have any particular questions, let me know. First and foremost, they're going to revise the definition of signs and laboratory findings to clarify that one or more signs or one or more lab findings or both constitutes objective medical evidence. Here's what you need to understand. Whenever Social Security is trying to determine whether you're disabled, they rely heavily on objective medical evidence. This is something that doesn't really lend itself to an opinion. It is what it is. Like, for instance, if you get lab work done and, you know, your labs reveal something, that typically reveals what's going on with you. So it's kind of what it is. In this instance, what they're going to say is if there's more than one or more lab findings or signs, this constitutes what we call objective medical evidence. It looks like here it looks like here number 2, they revised proposed regulatory text for AMS optometrists, which is basically acceptable medical source optometrists in the final rules to refer to the scope of practice in the state in which the optometrist practices. So here we've also got here that it says, for those of you who've never used this word before, let me throw something out there to you. AMS is referred to the acceptable medical sources. There are certain providers that Social Security deems to be acceptable, meaning they tend to give great weight to their opinions unless the evidence points to the contrary. There are other things that they call medical sources that are non-accepted medical sources. And you think, I don't understand. Think of it like this. Anybody who can provide, providers that typically provide can provide a specific medical diagnosis. Not saying nurses can't, not saying nurse practitioners can't, but the focus tends to be on the doctors. So their focus more on acceptable medical sources are going to be your doctors, your dentists, your surgeons, things like that. What they've said in this rule, though, is that audiologists, which previously hadn't been considered an acceptable medical source, they're saying that if the audiologists are speaking in the context of a hearing loss, auditory processing disorders, and balance disorders within the scope of their practice only, they are considered an acceptable medical source for those finite things, if that makes sense. So that for those of you who are trying to like, okay, so what are you trying to say? I'm just trying to say that if you've got an audiologist that talks about your specific disorders relating to your hearing, but then talks about other things as well, the other things, not necessarily acceptable medical source, then not so much. The hearing portions, they will, okay? Interesting, and this is actually fairly new. We recognize physician's assistants as acceptable medical sources for claims filed on or after March 27, 2017. People, that one is fairly significant. Let me tell you why that's significant. Historically, physician's assistants have not been treated as acceptable medical sources. They've been treated as other sources and so forth. The medical sources that are what we call other medical sources. Why is that important to you? Most of you, if you're going to your doctors, you may not have the opportunity, especially if it's a big provider, you might not have the option to go and talk to your doctor. So what ends up happening is that you talk to someone who's called a PA, a physician's assistant, and you're probably thinking to yourself, well, is this person like a doctor too? No, but technically they're not a doctor because they haven't gone 4 years medical school, internship, residency, the whole nine. But they are, the physician's assistants, they do certain things that are similar to doctors. They're able to diagnose, they're able to provide treatment, they're able to prescribe medication. Boom. So the fact that you've got, the fact that they're now recognizing it means they're now no longer limited just to the doctors. They've now added physician's assistants, that's a pretty big deal. Like I said, especially if you find yourself going to like a clinic, okay, or like a health department and so forth like that, it's probably not uncommon that a lot of those providers are physician's assistants. So that's a pretty big deal, okay? Now, they revised, for number 5, they revised the title and definition of the category of evidence from non-medical sources. Looks like here, we changed it to evidence from, it says here, changed it from statements from non-medicals to evidence from non-medical sources. They revised the definition for brevity and to explain why we receive evidence from non-medical sources, either directly from the non-medical source or indirectly, such as forms or other administrative forms, records. All right. Sometimes, remember, Social Security does not rely solely on just the medical records. It's not the only thing that they rely upon. They also rely on evidence from other sources. Previously, it was limited to just basically saying statements. But now what they're doing is they're telling you is that they're recognizing that you may provide evidence, and it could be a variety of different evidence. It could be a statement, it could be a form that they completed, it could be a letter that they've written on your behalf. And so, like I said, other non-medical sources, it could be like, let's say your nurse writes something or your nurse practitioner writes something. That is something that the court or Social Security needs to take in consideration when they're looking at the scope of your condition for purposes of determining whether or not you're disabled. All right. They clarified again that a statement about whether an individual is disabled It has a severe impairment as a statement on issue reserved for the commissioner. All right, this pops up a lot, and I tell people this, that your doctor saying that you're disabled, your doctor saying that you're disabled is not within their purview, meaning just because they say it, the Social Security does not have to agree with it. The final responsibility of determining whether you're disabled or not falls squarely on Social Security, because that's who you're trying to get benefits from. So it's just more of a, to let you know, this falls within our scope. Okay? Now, looks like here we revise the rules so that we will consider all evidence we receive. We have specific articulation requirements about how we consider medical evidence and prior administrative medical findings. Here's what you need to understand in the grander scheme of things. The reason why Social Security wants you to provide everything is because they don't want you to be selectively picking and choosing what you think is relevant. They want you to provide everything. Okay, so they're letting you know here to clarify that even though they're taking everything, they're still going to consider medical opinions. They're also going to be looking at your prior medical findings, administrative findings. Here's something that most people don't realize, because sometimes people lose sight that the date you indicated that you became disabled is the important date that they're hanging their hat on. Okay, so they're going to look at historical information. So let's say, for instance, you say you became disabled on January 1st, 2017, but the problem presented itself 2 years ago. They're going to look at that for purposes of historical, but the evidence is really what they're going to be focusing on is the information primarily, I say again, primarily from when? The date you indicated you became disabled. All right? So let me see, let me see, looks like here, a couple more here. For claims filed on or after March 27th, 2017, we're revising our rules to state that our adjudicators will articulate how they consider medical opinions from all medical sources, regardless of whether or not the medical source is an acceptable medical source. All right, follow me on this one, because this is going to be a little goofy. All right, as we talked about earlier, there are two types of medical sources. There are acceptable medical sources, and there are basically what we call other medical sources that are not acceptable. That's usually your nurses or your nurse practitioners, your therapists, your counselors. What they're telling you is usually what happens is, you know, they typically, whenever you get a medical opinion, and let's back it up a second. Okay, let's back it up a second. What is a medical opinion? A medical opinion is a statement by your doctor or your provider or your medical source about what you can and cannot do despite your impairments. It is not just merely a statement from your provider saying that you cannot work. It's really a breakdown of what your diagnoses are, okay, what limitations you have, and how those limitations may affect your ability to do work, and additionally, what evidence they relied upon in making that determination. Okay, with me? All right. Now, typically, the one that you really focus a lot of your attention on are the ones that are written by your treating doctors. But let's be real. Let's be real. When the person is coming in to talk to you, sometimes you may not know if that's a doctor. You don't know if that's a doctor or a nurse practitioner or a physician's assistant or even a therapist or a counselor. You don't know any of that. How many of you have found yourself in a situation where you have a counselor for mental health treatment who's willing to write a form for you, but they're not a doctor, they're a licensed mental health counselor? Found yourself going to a treating doctor thinking it's a treating doctor, but it's really a nurse practitioner who sees you every week, every month, and the doctor only sees you like once every couple of months, but this nurse practitioner knows you so well, and they're willing to write a form on your, fill out a form or fill out a statement on your behalf. What they're telling you here is that after this date, we're gonna articulate, in this rule, they're articulating how they consider the medical opinions from all medical sources, regardless of whether it's a regular doctor, which is considered a acceptable medical source, or anybody else, like a nurse practitioner or a counselor, therapist, things of that nature. So that's huge for you, okay? Now, it says they revise the factors for considering medical opinions and prior medical to both emphasize there is not an inherent persuasiveness to evidence from, let me see, it's medical care, primary care, CE sources over, let me see, it looks like medical care, primary care, CE sources over an individual's own medical source. Okay. And vice versa, and to highlight that we continue to consider a medical source's long-standing treatment relationship with the individual. Oh, I understand what they're saying. Basically, what they're telling you in this particular instance, when they say MCs, pre-Cs, okay, medical consultants, psychiatric consultants, or CE sources over an individual's own medical sources. Okay. This is going to sound goofy. Follow me here. How many times have you gone to an evaluation by Social Security and you freaked out because you're thinking that Social Security is going to rely solely on what that provider says? Or better yet, how many times have you contacted Social Security and they're saying your case is under review? And that means under review means there's a doctor who's never seen you, who's never spoken to you, who's never evaluated you, who's just looking at your medical records and providing an opinion. What they're saying here is that they don't want you to think that just because they got that statement from those doctors that it's more persuasive than the doctor you've been with for a while. At the end of the day, they are going to continue to consider the medical source's long-standing treatment relationship with the individual. Now, how this is applied, we're going to see how this thing works itself out accordingly. But the way this works, because we've seen this happen as a representative, we see this happen all the time. You'll look in the file and you'll have a psychological, I'll give you a great example. I have a case right now where I have a client that literally has been going for psychiatric treatment for almost 2 years. Months and months, every month she goes for treatment. She got an assessment from her medical provider that says she can function at all. Guess what happens? They send her records to an evaluation from a doc, send her for an evaluation with a psychologist, and of those 24 appointments, 24, they only sent one copy, just one. And with that and the interview the person had, they said, oh, we think she's fine. But it just so happens she happened to have a good day. But they didn't have a good longitudinal picture of the entire period of time. So you can see how frustrating that could be for her when she's sitting there going, I don't understand how can they, as this one doctor who only saw me one time, say, oh, they can concentrate, they don't have any problems doing tasks and so forth. But I got a doctor that's been seeing me for almost 2 years who's saying the contrary. And basically what they're clarifying here is like, listen, just because we cinch to these doctors doesn't mean we're going to automatically give them deference. So keep that in the back of your mind. We added regulatory text in this 10. We got 5 more of these to go. We've added regulatory text in the final version that is that there's no requirement to articulate how we consider evidence from non-medical sources about an individual's functional abilities and limitations using the rules for considering. Okay. Basically said, what they're saying here is there's nothing that requires them, starting March 27th, there's nothing that requires them to articulate how they consider evidence from non-medical sources about an individual's functional limitations. And so basically what they're telling you is, let's say that there's some statements in there, not a medical source statement, not a source statement from, we're talking about it, was we talked about that a little differently and so forth. Let me go back here. We're not talking about here, about earlier about medical opinions from all medical sources. This is from a non-medical source. So what they're telling you here, let's look at the two together. If a medical source gives you an opinion, regardless of whether it's an acceptable medical source or not, they're going to give you a breakdown about how they evaluated that opinion. That rule does not apply to a non-medical opinion. And I'm talking a non-medical source. So I'm talking about if it's someone that is not a medical provider, like let's say your supervisor gives an opinion or HR representative gives an opinion and so forth, that's fine. They're going to look at it and they're going to keep right on trucking. There's nothing that requires them to have to render an opinion about that. Okay. Now, they clarified a section heading. That's number 11. No big deal. We added regulatory text about how we consider and articulate our consideration of opinions from medical sources who are not accepted medical sources and from non-medical sources. We're adding our current policies found in Social Security ruling 06-03P, which explains how we consider and how and when we articulate our consideration of opinions from medical sources who are not acceptable medical sources and from non-medical sources. So again, I know that's a mouthful. Just think of it like this for those who may not be aware of. If the person who's providing an opinion about your condition is in the medical arena, whether I mean medical meaning they're a therapist, they're a counselor, they're a nurse practitioner, they're a physician's assistant. If they're in that arena and they provide an opinion about what you can and you cannot do, Social Security is going to evaluate that opinion. If the person is a non-medical source, they're not a nurse, they don't have any medical training, whatever the case may be, they're going to look at that and tell you they don't have to provide an opinion. Okay? All right. Three more to go. They said they revised the criteria for which audiologists may perform the audiometric testing. And so that's different. That means they revised the listing there. They said they did not adopt the proposal to recognize independently practicing psychologists with master's level education as qualified to be consultants. Okay, we will continue to follow our current, which is about who is qualified to be a PC. Okay, a psychological consultant. Basically here, what they're saying is, right now, whenever they have a review of your file and there's a medical impairment, they use a psychologist or psychiatrist. I guess there was a proposal to basically add those persons with like a master's degree to that level, just a master's degree, not a PhD, not a Psych D or MD, but a master's degree. And they said, no, we're not going to do that. We're going to still rely upon this. All right. And they also made a number of non-substantive revisions to use consistent terminologies throughout. So, okay. So, what does all that mean to you? All right. First of all, it means that once March 27th, 2017 comes in, all of these things are going to go into effect. Okay, so that's the first thing you need to be aware of. If you want to know what is the biggest things from looking at this and you say, okay, Attorney Reeves, what is the biggest things that you take from this? 4 things jump out at me. 4 things really jump out at me. 1, an audiologist, for purposes of dealing with impairments regarding hearing loss, auditory processing disorders, and balance disorders within the scope of their practice are now considered an acceptable medical source. Okay, so for that limited purpose, that makes sense there. So that's one big thing. Physician's assistants are now going to be recognized as an acceptable medical source, which is huge for you, especially if you find, because I don't know how many of you have representatives, and you go talk to your rep if you're not sure if this is right and have them look this up for you. But a lot of times what happens, I know as a rep in the past, and when people say, hey, I got somebody who'll write a statement or fill out a form for you, I'll ask the question, is it a doctor? Well, I think so. And then I'll look in the form and I'll say, what's their name? Oh, Dr. Johnson. And it'll be not Dr. Johnson, it's James Johnson, PA, which means they're a physician assistant, which I already know that doesn't really help me a lot. What they're saying now is that they've elevated those people from being a regular medical source that is not an acceptable medical source to now being an acceptable medical source. So that's huge. The other thing that's huge for you is for you to remember these last 2 points. One, for purposes of here, Social Security is now going to articulate their reason of how they consider the opinion of all medical sources. So that means if you're nurse, and this is starting March 27th, so don't get gung-ho and think, oh, I'm riding this thing out today. No, starting March 27th. What you need to know is keep this in the back of your mind, that it doesn't matter if it's a doctor, psychiatrist, licensed mental health counselor, nurse practitioner, if anybody provides a medical opinion about your diagnosis and what your limitations are, not that you're disabled, but what they think you can and cannot do despite your impairments. Social Security will evaluate and articulate how they consider those opinions, which is huge because it can tell you if they deny you, you now have a basis of what to rely upon to look at why they basically threw that thing to the side. The other thing that's important for you to realize and remember is that if you get an opinion about what you can do from a non-medical source, Social Security does not necessarily have to give you an opinion about how they considered that. So that's important as well. Oh, and one other thing, again, the last point, and I said 4, lied, 5. This is really crucial and key to you, okay? This is crucial and really key to you for you to understand in the grander scheme of things so that you know this going forward. So that there is not an inherent persuasiveness evidence from medical consultants, psychiatric consultants, or consultative evaluators. So that means when somebody is reviewing your medical records and they render an opinion, they don't automatically give due deference to that provider. If you go to a consultative evaluation and that one person reviewed you, don't automatically think that your case is going to be dead if they don't find that you're disabled. Now, the proof is in the pudding. The reality is that we got to put this thing in the application. There's going to be some people who are probably going to, trip over this a little bit, meaning as the court gets comfortable with these new rules, there are going to be those. I always tell people the one thing about rules are black and white. How they're applied is gray. So what ends up happening is that all these unique facts pop up, and then that's why we go into court and we litigate. I'll tell you is this: as these rules are being rolled out, and rolled out in this case would be March 27th, because of all these things that I was just talking to you about doesn't go into effect now. As these rules are rolled out, all right, keep in mind keep in the back of your mind the understanding and the reality, okay, that there may be some mistakes made along the way in the implementation of these rules. Make sure you have your representative with you. Your representative will basically, if they make a determination that something's not applied appropriately, they will appeal it accordingly and keep that fight going. And what ends up happening a lot of times is when things like this happen and it gets taken out of the Social Security and into federal court and they fight it out, the court basically uses that opportunity to clarify if there's any type of misunderstandings or misapplications of the law. Whoop, there it is, people. That is the new rule that's coming out. It's the revisions to the rules regarding the evaluation of medical evidence under. And for those of you who are looking for, it looks like it is federal. It's on the Federal Register, page 5844, Social Security Administration 20 CFR 404 and 416. I know I've just gone through a lot. If you have any questions, this is your time to jump in there and let me know what you got to say. If not, I will tell you, as always, in the future, if you ever have any questions about different things, you want to know, and so forth, we do these things. For those, just to let you know, we do Disability Talk Live every first and third, again, every first and third Wednesday at 4 p.m. So for those of you who like the videos, I really would love to either one, get your videos, answer questions sooner, because you're like, man, well, he's going to ask a question, but I don't know when it's popping up. And you just would rather just say, listen, this is what I want to know. This is your time, people, to do it. Okay, this is your time, people, to do it. For those who are not able to make it, okay, those of you who are not able to make it, real talk, you can always post your comments here. But for those of you who are worried, because it's easy, attorneys, we get sidetracked, and you want to know, I want to make sure I get my question addressed. This is what I want you to do. Send me an email. Real simple. Shoot me an email. Anthony.Reeves, R-E-E-V as in victory, E-S, at reevesfirm.com. Shoot me an email there. Or you can send it to Disability Talk. If I remember correctly, it's like Disability Talk and Disability Talk Live at reevesfirm.com. But just send it to me. It's just easy that way. I don't remember the email, but you can remember that one. Send me an email and make sure you specify, Attorney Reeves, when you do your show on this day, please make sure you answer this question for me. And guess what? I'm going to print that bad boy out and keep it with me handy, so that this way, when I get ready to make it do what it do, I'm going to hit those questions first before I jump in. Okay? As always, number love for you. We're going to have the videos continue popping off and starting again tomorrow, as we always do. But if you want your questions answered live, you can always check me out here. You can always go to my, if you have a pending disability case, you can always go and fill out a free claim of evaluation on my website, www.reevesfirm.com, or you can go and send me a contact information, or check me out on Reeves Law Firm on Facebook.com. And because I'm on there fairly regularly on that page, and people ask me questions on there all the time. So I'm always here for you. Let me know if you need anything. I'm so glad to have you here. Have a wonderful day. Stay out of trouble. And as always, this is Attorney Reeves, and this is your Disability Talk Live.